5 seconds to go. Start. If a disease is accepted as having arisen in service, it must also be established that the conditions of military service determined or contributed to the onset of the disease, and that the conditions were due to the circumstances of duty in military service. Stop. Para. Rule 14b of the entitlement rules relied upon in Rajbir Singh Supra is not attracted in this case, because the respondent was not discharged on account of any disease, ailment or disability, but for administrative reasons. Stop. The rule is only attracted when a disease leads to an individual's discharge or death. Stop. Such disease is ordinarily to be deemed to have arisen in service, if no note of it was made at the time of the individual's acceptance for military service, but not always. Stop. In any case, the presumption under Rule 14b of the entitlement rules is rebuttable. Stop. If medical opinion holds, for reasons to be stated, that the disease could not have been detected on medical examination prior to acceptance for service, the disease will not be deemed to have arisen during service. Stop. There was no direction on the review medical board to give any opinion as to the question of whether the ailment of the respondent could or could not have been detected at the time of his recruitment. Stop. Furthermore, the mere fact that an ailment or disease may have arisen in service does not mean that the ailment or disease is attributable to service conditions. Stop. Para. In the instant case, as observed above, the discharge of the respondent was not on account of any disability or disease, but on administrative grounds, and such discharge was not questioned for 2 decades. Stop. The judgment in Rajbir Singh Supra or the judgments relied upon in Rajbir Singh Supra have no application in the facts and circumstances of this case. Stop. The learned tribunal noted red ink entries in the service records of the respondent on the ground of unauthorized absence, but arrived at the purported finding in effect that the absence of the respondent was only on account of his ailment disability. Stop. Such finding is patently conjectural, and not based on any materials on record. Stop. Para. Moreover, even in the case of discharge on account of any disability or disease, the authorities might dispute that such disability or disease was caused or aggravated by military service. Stop. The medical board might, for reasons to be stated, give an opinion that the disease could not have been detected on medical examination prior to appointment, in which case the disease disability would not be deemed to have arisen during service. Stop. Para. Moreover, as provided in Rule 14c of the entitlement rules, if a disease were accepted as having arisen in service, it must also be established that the conditions of military service determined or contributed to the onset of the disease, and that the conditions were due to the circumstances of duty in military service. Stop. Para. Even though, the tribunal accepted that there might be cases, where an ailment disease could be wholly unrelated to military service and the denial of disability pension could be justified on that ground, the tribunal overlooked the mandate of Rule 14c of the entitlement rules. Stop.